Hello, everybody. My name is Daryl Cartwright, and I'm an attorney in Birmingham, Alabama. I practice in the area of estate planning law and practice throughout the state. I wanted to present this short video today to hopefully make you a little more comfortable when it comes time for you to execute your estate planning documents. Certainly, the procedure that I follow may or may not be the one that you and your lawyers follow, but it probably is fairly similar. And certainly, this is the procedure that I actually use. So, if you're my client, this is what to expect. First of all, we've already engaged in the estate planning process in terms of we've spoken, we've met, I've reviewed your materials, information, we've discussed what the best options for you are, and hopefully we're at the point where we have had the documents prepared in draft form, and each of us have the documents in the same documents in hand. You have been able to review those documents. And before the time for us to have this estate planning execution conference, you should have read those documents thoroughly and had the opportunity to ask me any questions that you may have concerning those documents, concerning any issues related to those documents, and made any revisions that are necessary as well. Certainly in the event that you arrive at my office and you have questions or revisions that are necessary, odds are very great that we are not going to execute documents that day. And I do that for a couple of reasons. The main reason is that I need to make sure that you are comfortable with the documents at home in your own presence, and you've had an opportunity and time to actually review those documents that you have. And that doesn't present itself if we're making changes at the last minute. I don't like that to be the case at all. So it's very, very important that, that by the time that we have scheduled this meeting, you're very comfortable with the documents. You've asked me all the questions that you can have, and you're comfortable with any revisions that need to be made, and they are made, so that the documents you have are the same documents I'm going to have at the will execution conference. At the meeting, we will initially meet just you and me, outside any witnesses or notaries, because that's sort of my last check to make sure that you are comfortable with all the documents, that you've reviewed them. And I'm going to explain this process and this procedure to you during that time as well. So you're comfortable with it and you know what is about to occur. Now, again, as I said, unless the questions are just some relatively minor questions, if they're substantial, we probably are going to reschedule the execution of those estate planning documents for another day for good and valid reasons. But let's assume that during this meeting that I have with you that there are no substantial questions, and in fact we're ready to proceed. At that point, what I will do is call in the witnesses and the notary, and I may be, just depending upon the day and where we are executing this, I may be a witness or a notary. There's no prohibition against that occurring, and I am a notary public, so I can do this myself as well. I will ask you, we'll probably start with your last will and testament. And I have pretty standard questions that I typically ask, and I do this for a reason. I've done this hundreds of times, and I can truthfully testify, if ever I need to, that I've asked these questions, and the witnesses can truthfully testify, if they need to, that these questions were asked and you've answered appropriately. The first question is generally, have you read this document that purports to be your last will and testament? And does it dispose of your property as you wish? And your answer there needs to be yes. Yes, I have read this document. Yes, it does dispose of my property as I wish. Now, if you know my personality, I'm a laid back kind of guy. I like to kid around just like the next guy, but this is not the time to be joking. This is a serious matter. The execution of your estate planning documents is a legal, formal occasion, and we need to make certain that it's respected in that way. The witnesses need to be able to testify, if ever they are called to do so, that it was treated with the formality that it deserves. So you don't need to be joking around saying, well, you know, somebody's holding a gun to my head, somebody twisted my arm, they're doing this or else, anything like that. No jokes, just the facts. There used to be a Dragnet show, and they used to say, "Just the facts, ma'am." Well, it's just the facts, ma'am, or sir, as the case may be, in that situation. The second question is a natural follow to the first question, and I'll ask you if you're signing it today under any undue influence, force, or constraint of any kind. And your answer to that must be no. Again, no place for jokes to be done here. The witnesses have to be able to testify to that. That's part of the statute for a self-proving will, that actually the document must be signed under no undue influence, etc. For any legal will in the state of Alabama. If you're unduly influenced, it's not a valid will. So certainly we want to make sure that your will is valid and protected. The last question that I ask is not completely required by Alabama law, but I like to ask it for a couple of reasons. In Alabama, the testator must be at least 18 years of age. And I like to ask the testator, that's the person signing the will, you in this situation, if you are over the age of 19. And I do that for several different reasons. But suffice it to say, if I ever had an 18-year-old that was signing the will, I'd ask a different question for that one. I just never have. Mine have all been 19 or older, usually substantially older. These answers should all be serious and be treated that kind of way. The other estate planning documents, whatever they may be, maybe they're a healthcare power of attorney or healthcare proxy, a general durable power of attorney, a living will, declaration, etc. All need to be done in a similar kind of fashion. The healthcare power of attorney, for example, there'll be a slight modification. For example, I may ask you something that says, do you understand that you are giving another person the power to make healthcare decisions for you in the event that you are unable to do so for yourself? Similar type questions about if you're signing it of your own free will, etc., but maybe an additional question or so related to that. The power of attorney, same kind of thing. I'll ask you, do you understand that you're giving another person the power to make financial or legal type of decisions and execute documents on your behalf when the power of attorney is legally effective? And the reason that I ask it that way is because on occasion, the power of attorney will be a sprung power of attorney, meaning it has sprung into effect immediately. And then on other occasions, it will be a springing power of attorney, which means that it will only spring into effect at a later time, generally when you are incapacitated. So the question that I ask will be, do you understand that you're giving someone this power when this power of attorney is effective, whenever that may be? And of course, your answer to that must be, yes, I do understand. And if you don't understand, we shouldn't be executing that document. That's just a real key. Now, at the conclusion of each one of these documents, and let me go ahead and mention the living will. I'll mention that one last. Living will or a declaration with respect to certain medical services. Fairly straightforward document, I think, but I'll ask you, do you understand that in the event you have a terminal condition for which there is no hope of recovery, it is your desire to die naturally without the use of machines to artificially prolong your life, and with the use of what's known as comfort care only, medicines and treatment designed to alleviate pain and suffering. Do you understand that this is what you are requesting? And you must answer yes, that you're doing that. You understand it, you're doing it of your own free will, etc. Now, after we kind of go through each document, we're going to do it one at a time. I've kind of gone through all of them, but actually you do it one at a time. We'll start with the last will and testament usually. You'll sign and usually date the will, and then it will be passed to the witnesses. And the witnesses will sign, assuming they've witnessed the document being executed and heard the correct answers. And they will typically, in my documents, will include their address. And we do that for a number of different reasons as well. And then it will be passed to the notary public, who has heard and seen the sworn testimony in front of him or her, and as to the testator and the witnesses, and they will notarize the document. And at that point, it's a legal and effective last will and testament. And again, we'll do the same thing with respect to each of them. And each of the documents have different requirements. For example, the power of attorney only must be notarized. The healthcare power of attorney doesn't have a notary, but it has two witnesses. So each document is a little bit different with that in that respect. Now, after all the documents are signed and executed, witnessed, notarized, etc., what I will do is I will take all of the documents myself, and I will assemble them, and I'll put them together so that I can scan them into a digital format, and I will keep a copy by digital format only. I will send you an assembled packet of all the original documents. I generally send it back by US mail with a tracking number, and I will also send you, for your purposes, a digital copy as well. And that way you can have a digital copy on your computer hard drive. You can print out as many copies as you want, and you can keep the original documents in a safe place. I will also send you an important documents checklist with the packet that I send. And that's a document that you will fill out yourself that identifies certain documents, important information, not only your estate planning documents, but things like life insurance or house insurance or car insurance or whatever, and where they are located. And I would ask you to keep that in a very accessible place. Now, your estate planning documents may be under lock and key somewhere. They may be in your office file cabinet that's kept locked. They may be in your bank safety deposit box. Wherever those are located is fine, but the important documents checklist needs to be something that's very accessible. I've had some clients that have put it in a clear sleeve type folder and put it with a magnet on the side of their refrigerator so that it is always there and everybody knows. Nice and handy. Anyway, that's all that is involved in the will execution conference. So hopefully this may make you a little more comfortable when the time comes, and hope that this has been helpful, and I will see you soon with my next video. Bye.